Hi, everyone, and thanks for joining us today. We're here at Stanford Law School for our webinar on trends in FCPA investigations. Here with me today are Brendan Cullen from Sullivan Cromwell, Joe Grundfest, professor here at Stanford Law School, and I'm Laura Oswell, also from Sullivan Cromwell. I think we wanted to kick it off today with kind of the main topic, which is what's going on in the world of FCPA. So, Joe, do you want to lead us off?
Well, you know what's interesting in terms of what's going on in the world of FCPA? It's more what's not going on rather than what is going on. We run a website in conjunction with Sullivan and Cromwell here at Stanford Law School, and one of the things that we track that other people don't is disclosures in SEC filings by companies of the fact that they are under FCPA investigation or conducting their own internal investigations. Historically, what we've typically seen is somewhere between 16 and 31 companies per year newly announcing FCPA investigations in their SEC filings. In the first half of this year, of 2019, we've observed only 2 such announcements. This is a remarkably small number. There are a variety of different explanations for this remarkably small statistic, and given the data that we have, it's impossible to differentiate among these different explanations. One explanation is simply that the government isn't bringing that many actions. Another explanation is the government isn't bringing that many actions against companies that have to do SEC filings, and instead they're bringing more actions against companies that don't have to file. A third explanation is more actions are being filed, but for a variety of reasons, companies are reaching the conclusion that it's unnecessary at this stage to disclose those filings. And of course, it could be a combination of any one of those factors, or all 3 of those factors, that winds up giving rise to a situation where we only have 2 companies in the first half of 2019 that have actually disclosed new filings. I don't, Brendan, Laura, any observations, any experience consistent with that?
Well, the only other observation I would make is you mentioned 16 as the prior low, but that was just last year. And so if you take 16 from 2018, 2 from 2019, those 2, that year and a half combined, would still be the lowest year on record since we started keeping track in the Clearinghouse of reported FCPA investigations. So whatever it is, it seems like it's not just a blip in 2019. It's possibly less blip, more trend. I think you've offered the explanations that make sense. It's hard to imagine that what has happened is a sudden worldwide straightening up and flying right on the part of all corporate citizens. No one's paying bribes anymore.
You don't think everybody's gotten religion and there are no FCPA violations anymore?
I suppose it's on the list of possible explanations. Yes. I would put it way, way down below ones that have unicorn in them. But it's interesting, and whether this is to do with different levels of enforcement activity on the part of the government, where there is to do, as you say, with different views as to the materiality of investigations or the like. Who knows? We'll see. As we know from studying these things in conjunction with Joe and the team at the Clearinghouse, these things have a lifespan, and the lifespan is long. Right. And so when you see investigations resolved, you know that resolution, whatever form it takes, was years in the making. And so we'll see 2, 3, 4 years hence what these 2 were, what the 16 from last year were, and maybe we'll have an understanding of why they were it.
And in fact, given the life cycle of FCPA investigations, I bet it'll take us 5 years before we'll be able to differentiate among these different hypotheses. Laura?
Right, and I would just say that I think we're going to show some other data that may partially explain this or put this into context, exactly. Which is that there's a phenomenon of clearing out some inventory. There's been a lot of enforcement action, some pretty high dollar enforcement action over the course of the last 2 years, measured against, relatively new levels of disclosed cases. And I think the other trend that we see that puts this into context is the number of foreign companies that are the subject of FCPA investigations, which may be consistent with your hypothesis about non-reporting companies as the targets and thus less disclosure of announced investigations, but it may not paint the whole picture.
I think that's right. And again, so if we look at the sanctions per year, and if you use that as the measure of government enforcement activity, it's a robust market. And what's intriguing is this is the measure that most people look at. It's sort of an output measure rather than an input measure. And what we try to do at Stanford and in conjunction with Sullivan Cromwell, we try to look at the inputs that people are missing as well as the outputs. So it's a stock and flow approach. So if you look at the outputs, the announced cases, the size of the penalties, this is a robust year.
Yep.
All right, we're seeing a lot of activity coming out of DOJ and SEC, but the interesting thing is we're not seeing the same level of activity with regard to reported new investigations. And again, you look at that number and you get the same result. There's a lot of activity, whether you count noses, all right, in terms of the number of settlements, or whether you count dollars, the dollar size of those settlements. Now, one of the other interesting patterns that we're observing here is that it appears that with regard to ongoing investigations, if we look at the entire universe, they're roughly evenly split between domestic and foreign entities.
Yep.
So we find about 30 domestic, 27 foreign. But if we have a look historically at settled items, all right, at settled matters, it's much more strongly domestic over foreign. Historically, the data show that it's 116 settled domestic, all right, and 63 settled foreign. So closer to a 60-40 split historically. We're now running at 50-50, meaning that we're seeing more resources devoted to foreign issuers that happen to be subject for a variety of reasons to FCPA jurisdiction. Laura, could you expand on how that happens and why we might be seeing that?
Well, I think one factor that we've seen a lot of that dovetails really nicely with this data is the increased multinational cooperation in the realm of FCPA enforcement. So whereas before you would see enforcement actions led by the DOJ and the SEC, and that was kind of it, we're seeing more and more actions announced where multiple countries are enforcing at the same time. And so if you think of this as a multinational effort, you're going to see a better balance as between U.S. and foreign companies. I mean, you think back to 2016 in the VimpelCom matter where you had something like 11 or 12 authorities from different nations all credited with contributing to that investigation and the reach of that investigation. And then more recently with Petrobras, also a multinational investigation. I think that really contributes to this data.
And related to that, what we're seeing is when you have a settlement, it's not just that you have a payment to DOJ and SEC. You can have a payment to DOJ, SEC, and Brazilian enforcement authorities.
Exactly right.
So what we're now moving to is an environment of one-stop shopping. All right,
sorts,
where it's a little bit like it's the Amazon of FCPA
right.
and corruption. The U.S. authorities, right, wind up picking up multinational enforcement, and everybody winds up cooperating that way.
Yes, and I think it's interesting because you see a variety of connections, right? You see cooperation with the Netherlands, with Brazil, maybe not countries that you would necessarily have expected to see DOJ and SEC cooperation with. I also think that it's a trend that's going to continue, if for no other reason than once these authorities have the pattern and the knowledge and kind of the personal relationships to work together, I think you would expect that to continue and expand over time.
I think that's right. And Brendan, from your perspective, is this a good thing or a bad thing or neither?
Well, so from the perspective of a defense lawyer, the fact that many, many more prosecutorial agencies are going to be investigating your clients and demanding money is hard to describe that as a good thing. It is fascinating. I was looking at the Clearinghouse earlier today, and there's a chart that shows what percentage of settlements involve payments to whom. Cool. And in the old days, and the old days is up to about 5 years ago, it was always only U.S. regulators that payments were made to. Since then, it's almost never that. It's almost always DOJ, SEC, and others, Brazil, Switzerland, Italy, whomever. In the Petrobras case that Laura mentioned, I think there have been something like 8 or 9 announced settlements, all but one of which involved payments by the party resolving the case with regulators to other than DOJ, SEC. A question that always arises in the context of the FCPA, when a company finds out it might have a problem somewhere, somebody somewhere is paying a state-owned entity, employee, or a foreign official a bribe, is do you self-report or not? And one of the big questions that you always ask yourself is, if I don't self-report, what are the chances that some regulator is going to find out? Well, with international cooperation of the sort we're seeing very, very hard evidence of, the chances that you will be able to get away with paying a bribe somewhere and the DOJ never finding out because nobody ever tells the DOJ, that's dwindling all the time. You now have an army of regulators around the world who are on the lookout for this sort of stuff. As Laura says, they know what to look for. They know that if they do this right, they're going to stand to gain millions, if not tens or hundreds of millions of dollars in fines and penalties. And telling DOJ about this is a very beneficial way to make sure that this actually goes the way they'd like it to go. And so they have every incentive in the world to share this information with DOJ. DOJ is very generous in letting companies pay other countries' regulators to settle these matters and then just crediting that against what the DOJ would otherwise fine them. And so you now have a lot of, it's very, very difficult to convince yourself, well, you could try, but it's very difficult to convince yourself that no one knows about this bribe paying except for us and the foreign official to whom the bribe was paid, and no one will ever find out.
Well, another factor in that calculus is whistleblowers and the rewards that the SEC now can pay of 10 to 30% to people who come in with original information about violations of the federal securities laws. So the trajectory that I've seen pretty clearly in corporate boardrooms over the last several years is pretty much no matter what the alleged violation is, the probability that a company will think that it can keep the government from learning about that violation is going down, and therefore all other things equal, which they never are, the rationale for self-reporting earlier in the process actually increases. Is that consistent with your?
I think that's right. I think both the kind of risks, as you've both described, of, somebody's going to come up with this anyway, and that's kind of a company's worst nightmare, is to not be the first one to tell the DOJ or other relevant regulator about a potential problem, and the sophistication of boards generally about these issues, boards of companies both in the U.S. and abroad, that this is a very serious problem. I would say, though, that it makes those decisions all the more complicated when you realize that when you report to the DOJ, you may not be just reporting to the DOJ. That reporting may then go to authorities in a variety of jurisdictions. So that calculus of what does reporting mean, what is it going to entail, is no longer just a U.S. focused question. It's now a much broader question and makes that a very complicated discussion.
No, in fact, in my experience, you have to assume that other foreign jurisdictions will be informed of that activity, unless there's certain jurisdictions, certain geographies where our relations with the authorities there aren't as friendly,
right?
All right, as they might be. The other thing that we see when we look at relatively recent data from our clearinghouse is that with regard to completed investigations and ongoing investigations and the like, there's really not a huge change in terms of geographies. What we're really seeing is a concentration of problems in China and in Latin America. The numbers move around. Recent problems in Brazil have, brought the numbers up in Latin America. We expect that pig will move through the python and will move back towards a situation where, again, it'll be China in the strong lead, and then you'll have secondary activity in Latin America. And if you look at it by industry, you break it down by industry, you get a small numbers problem. It's really hard to draw a strong inference. But to the extent that we see patterns in the data, it appears that there's a shift to more FCPA concern in the financial services industry and away from oil and gas and natural resources. But again, these can be, very transitory factors that as a practical matter really won't make much of a difference. One other point that I'd like to raise is we also track the small number of companies, relatively small number of companies that wind up disclosing information about the costs that they incur in conjunction with FCPA investigations. And the most recent data point we have on that is the Walmart situation, where, and again, I'm going to round the numbers here, Walmart winds up paying approximately $300 million, a little bit less. And they publicly report that their remediation costs, the amount that they paid to the lawyers, the accountants, and everyone else dealing with the investigation and improving their internal systems, exceeds $900 million. So what we have here is a situation where the ratio of the process costs to the actual penalty is approximately 3 to 1. And when we look at the data in our clearinghouse, we actually find a span which is very closely related to the size of the investigation. So, for example, there's a small company called Veras. They paid $300,000, but it cost them $3 million.
Right. But looking at that and the kind of perspective of percentages doesn't paint the full picture. $3 million for an investigation is probably not that extraordinary, even for a small company. And who knows what their penalty would have been had they not handled it appropriately. So it cuts a little bit both ways. If you're getting in a small size, small scale like that, if you're getting a benefit because you are investigating, remediating, and reporting in a way that the DOJ finds satisfactory and therefore paying a much smaller penalty, I don't think the 10x multiple really indicates a problem with the expenses of doing the investigation. I think Walmart is a different story just because $900 million is a shocking number in absolute terms.
But let me turn that around on you, Laura, if I may. For a small publicly traded corporation operating in a difficult environment, all of a sudden having to find $5 million in cash with which to pay lawyers, auditors, and consultants may actually be a heavier lift net than for a company like Walmart coming up with $900 million.
It's fair enough. And I think that's something that companies have to manage as part of these sorts of challenges. When you have an issue kind of come to the board that looks like it needs to be investigated, that's always a thought. And it's something that I see companies struggle with frequently of how can we manage this and make sure we're handling this in a scaled way where we get the benefit of being a good corporate citizen and reporting and doing what we need to do, but without fundamentally crippling our business with cost. And I think there are ways to do that.
You know, another way of looking at, Brendan, I love your perspective, is that as soon as you wind up telling a corporation that we've got a potential FCPA problem, we've got to find out what it is. We have to figure it out. You know, the drop on the meter, you're going to be spending a few million bucks. That's the minimum amount necessary given the scale of these investigations. What's your experience on that?
I think that's probably right. You know, it's hard to imagine an investigation satisfactory to the regulators that can be done for seven figures. It just, if your employees communicate electronically and have been doing so for more than a year, they've created millions of documents. And just dealing with the documents is a very expensive proposition. And, you know, it's like when I have cancer removed from my nose, they don't just cut exactly the cancer, they cut a little perimeter. The DOJ and SEC is going to expect you to do the same thing. They're going to expect you to look around, not just at the guy who paid the one thing that you know about, but his coworkers, his manager, his underlings if he has them. Similar organizations in your company that are in similarly difficult markets or have state-owned entities for customers or the like. You'd be expected to go show that not only have you figured out what happened in this instance, you have established that that's the only one, or there were other things, but you found them too, and you've taken steps to ensure that this isn't going to happen again. And that is not a cheap proposition.
So the lesson here is, as soon as you have a sufficient degree of concern about an FCPA problem, and you decide that you've got to run it to ground, get ready to write a check for a minimum of several $1 million.
The other thing I would say...
That's the reality.
I think that's right.
Yeah.
The other thing I would say, though, is, and this counsels in further favor of self-reporting, is I think that the regulators would tell you, and I think my experience has been, that if you get there early, you establish yourself as a credible corporate actor trying to do the right thing, and you explain that you believe the situation is confined to this business unit or these bunch of guys or whatever it is, and you explain your plan to investigate this. You explain why you think that's adequate, why doing other things, looking at other parts of the company are not required. They're generally amenable. And if you come in with early established credibility, explain how you plan to get to the bottom of the situation, explain why you're not doing a company-wide sweep, by and large, if you can convince them that this is an appropriate way to proceed, they're fine with it. And you can avoid, if you do it right, the company-wide sweep, which can run to almost infinite dollars. And I do think, $900 million at Walmart, I didn't work on that. I have no idea how they ran up that large number of fees. But you wonder if it was because they were obliged or decided over the course of time to expand the investigation to this area, to that area. It looks like they did. They had to explain conduct in multiple markets as part of that resolution. So getting ahead of your investigation, having a good plan that you present to the regulators as an appropriate and reasonable response to the situation is a way of at least controlling costs to some degree.
So we keep coming back to this question about cooperation, controlling costs, interaction with penalties. Laura, the DOJ recently had some formal announcements around this stuff. What were those announcements, and how much clarity do they really add?
So the DOJ came out in the last year with both an updated enforcement policy, which relaxed a couple of requirements that I think companies had struggled with a little bit. One being the identification of individuals. It has been and continues to be a policy of the DOJ that one key part of cooperation and identifying all the relevant individuals involved in the misconduct, which is a struggle if it's a big, wide-ranging problem. And so they've made that more rational. You're supposed to identify the most substantially involved individuals, which I think just provides some clarity that was probably already happening behind the scenes. And the second piece of that was interesting and maybe a little bit smaller but important when you're doing these sorts of investigations is allowing companies to get cooperation credit, even if they use messaging systems like WhatsApp, where the messages may be transient and not able to be captured. In areas where the FCPA issues are rampant, like China, messaging applications like WhatsApp and others that are more transient are a way of doing business. And so kind of the rule that had been in place that you would not get cooperation credit if someone in your business was using those messaging systems was unworkable in practice. And I think the DOJ recognized that in its enforcement guidelines. The rest of the guidelines, I think, pretty much embody things that people were doing in practice already. Again, the emphasis on cooperation and what companies need to do to cooperate. And then I think on the more recent announcement about what are the hallmarks of an effective compliance program, again, the DOJ is trying to give companies more clarity, more guidelines, I think not only for the benefit of companies that find themselves in the midst of an FCPA problem, but also for the benefit of companies that are trying to avoid those problems. The guidelines that have been put out are actually very useful for all boards to look at as kind of, the hallmarks of what they should be trying to do. And the guidelines themselves really just boil down guidance that had been provided before and kind of the three key questions that I think are pretty obvious to, people that work in the space, which is, how is your compliance program designed? How is it implemented? And are you checking on it to make sure that it actually works? And the focus of the guidance has a lot to do with tailoring and communication and kind of how this all works together for companies.
There's another very recent development that comes out of the Delaware Supreme Court, which is not the place that people typically look for FCPA guidance. And the decision technically has nothing to do with the FCPA, but has everything to do with the FCPA. The decision came out in a company involved called Bluebell, where there was basically infected ice cream, and people died because of the ice cream. And the point that the Delaware Supreme Court made was that in order to establish that the board had carried out what's called its Caremark duty of care obligations, at a minimum you had to show that there was a compliance program that was reviewed by the board.
Yes.
And here, Bluebell couldn't show that happened. So, Brendan, what are the implications for an FCPA compliance program if you're thinking not only about credit, all right, with DOJ and SEC, but avoiding the collateral litigation that commonly follows here?
So it's probably a couple things. Laura said, I do think the guidance recently, it was in April 2019, it was announced, and it replaced guidance that previously had, I wrote these down because these numbers are sort of funny to me. There were 11 compliance topics with 46 subtopics. The new guidance boils it down to 3 questions, but then also expands it to 12 subtopics and 48 subtopics. So there's a lot of stuff in there to review. And the DOJ says in the introduction to it, I think this is right, not everything in here is required for every company. Some of these aspects of a compliance program will be more important for a particular kind of company or industry than others. And I think what every director who sits on a board of a company that is exposed to potential FCPA liability, which means you do business outside the United States, it's probably worth taking a look through those to see if you have confidence that your policies, which, by the way, you should get told about at least yearly. We know from Bluebell now. Absolutely. And someone should write down that happened.
It should be in the minutes.
In a board minute.
Yep.
that you have confidence that the people you have hired know that these are the hallmarks of a good compliance policy, or at least these are the things that the regulators are going to look for to determine whether you've got a good compliance policy. And some of that is, do your compliance people have direct access to the board? Do they report to the board without management around? Do they have sufficient stature at the company that when they say something is off limits or something's not allowed, people believe it? Does the CEO and other senior management embody a culture of compliance, or are they, sales guys who are fast and loose, and when they say don't do this, they really mean do.
Right. Or do this, but don't tell me.
Whatever you do.
Whatever you do, don't tell me.
So I think those are probably, and I think I know not just from Joe, but talking to others, the Bluebell really has scared people who sit on boards of Delaware corporations, which is most public companies, and it's probably a good place to start for making sure you're abiding by your obligations is taking a look at what DOJ has said.
Yeah, so a simple practice pointer, pretty much for every general counsel that's out there and for every corporate lawyer, is in addition to FCPA, make a list of critical compliance programs. Make sure that the board or the appropriate committee of the board reviews those programs on a timely basis. We have no guidance as to whether that should be annual, semi-annual, biannual. You could imagine exercising reasonable judgment along those lines, but most of the counsel that I'm talking to are assuming, well, we'll put it on an annual review cycle, and then we'll divide it up. So suppose there are 8 critical programs. We don't review all 8 once a year. We do 2 each one of our quarterly meetings and what have you. But this is a situation that I think does require a little bit of attention and some housekeeping. Some corporations will discover we don't need to change much. Other corporations will say, all right, we now have a bunch of longer meetings, and that's the price of poker, and that's what we got to do.
So Laura and I were just having a conversation. The Bluebell example is a good one. On the way here, about compliance has almost become to mean anti-corruption. So people who have compliance programs who didn't have them 10 years ago have put them into place. Often you can go buy an off-the-shelf compliance program that is an anti-corruption program. That's not enough. And the Bluebell, there was no corruption involved in the Bluebell case.
It was just killing your customers.
Lots of ways for a company to get in trouble that have nothing to do with corruption. And in fact, I think it probably bears mentioning that the changes in DOJ policy that we're talking about weren't to the FCPA enforcement policy. They were to the General Criminal Division assessment of corporate compliance. And that involves compliance as to securities matters, insider trading things, critical legal regimes to which your corporation is subject, FDA type issues, those sorts of things, I think are all aspects of a compliance program, not just are we making sure that we're not bribing guys in China.
So I think the lesson here is you should have a robust portfolio of compliance programs. You probably want to take the learning that we've evolved in terms of FCPA compliance, expand that model to the other compliance areas, and document all of that, and then elevate it roughly once a year, all right, so that the board or the appropriate committee looks at that stuff with an appropriate level of depth.
I think that's right. And the other piece of it, too, as Brendan said, is access, right? There's the thing where the board is kind of pulling information in and reviewing it once a year in a formal way. But the other critical piece of the FCPA guidance, and I think probably would satisfy Delaware as well, is that connection between your compliance team and the board. Do they have the relationship to come in on an ad hoc basis and raise issues? And it doesn't have to be the full board. Is it a committee of the board, right? But making that connection and giving compliance the sort of autonomy and power to be communicating with the board, I think, is a critical piece as well.
Yeah, and the saying in New York, if you see something, say something, that's not a bad phrase to use within corporations as well.
Yes.
Absolutely. So what else do we see going on?
So the one other aspect of some recent guidance from DOJ was to do with corporate monitors, and a monitor is in the course of a resolution with the DOJ or the SEC. Sometimes what the DOJ can insist on is that because your compliance program was so inadequate at the time of the problem, or because your compliance program at the time of the resolution isn't yet up to snuff, or they're not yet convinced that you get it compliance-wise, DOJ and SEC can insist on a monitor being put in place. And this is a third party, frequently a lawyer, who comes in with a team of lawyers to sit in your organization and review every aspect of your compliance program, review how you diligence third-party agents, how you do due diligence in acquisitions, everything there is to do that touches on compliance in the FCPA. And these are blindingly expensive propositions. It's basically hiring a miniature law firm, sticking it in your organization, paying them law firm rates. It's not hiring in-house lawyers, it's hiring outside lawyers, putting them in your law firm, in your firm, to act like a little law firm, and paying them their rates, which can be very, very expensive. And DOJ recently released a memo that had 4 principles that they would use in assessing whether or not to assign a monitor, all of which are sort of restatements of prior statements of principle for the same purpose, but in a memo that I think most people understood to be at least tonally communicating that DOJ gets it. Monitors are really expensive and not always worth how much they cost.
But on the other hand, monitors are common.
So I looked again at the FCPA Clearinghouse today to see if there was a trend, if there was anything to note. And in 2014, there were 0 resolutions with the monitor. Mm-hmm. And in 2015, there was only 1. And I think I bet if you went back, you could find me saying something like, "That's it, the monitor is dead. No worry about a monitor. They're not doing it." Monitors are back. 2016, there were 7 resolutions with a monitor. So I think they're very much still going to be a part of resolutions. The hope, I think, is that when they'll be imposed, it will be in situations where they really are warranted, where the cost of a monitor bears some rational relationship to the likely benefit of a monitor. So that's another recent piece of DOJ guidance that has come out this year.
And that's a major negotiating point when you're trying to settle these matters with the SEC and with DOJ.
Absolutely.
Yeah, and it dovetails with the compliance policy, which says that the DOJ will look at the status of your compliance at the time of the conduct and at the time that you're making your resolution. So that's a good incentive for companies when they discover a problem, if their compliance programs aren't quite where they should be, to very quickly bring those compliance programs into a shape where the DOJ can be convinced that you don't need a third party involved to help you get things where they need to be.
And in my experience, one of the most difficult conversations with general counsel and also with the board is around a topic that we've already discussed a little bit. Maybe we should do a little deeper dive. Do you self-report? Mm-hmm. If you self-report, when do you self-report? And what are the implications of self-reporting? As we've all earlier suggested, the calculus, for a variety of reasons, is moving towards self-reporting, but it doesn't always lead to that result. In your experience, what are the factors that boards need to consider, and how and why do you reach that decision to, in effect, turn yourself in and guarantee that you're going to wind up spending many millions of dollars on an investigation subject to SEC and DOJ oversight, even if you've done nothing wrong?
The problem is you don't often know if you've done nothing wrong at the time that you need to make this decision. And you have the way these things evolve often is with a small report of something that could be very big or could be absolutely nothing. And the calculus for the corporate board is how long do you let that play out? And how do you get the maximum amount of information to make an informed decision about self-reporting in a timely manner? So the real key, once you have that hint, that suspicion that something may be wrong, is to get a plan in place quickly to try to get your arms around it and really put some timing around that so that you're acting quickly and that the board can be as informed, or at least know what the next steps would be to become more fully informed as you're considering the self-reporting question. Because as we've discussed here today, there are all sorts of incentives that have been put in place to self-report. And the counter side of those are all the bad things that can happen if you do not, if you are not the first person into the DOJ or your relevant regulator to disclose an issue. And what we found in practice is that the DOJ and SEC are very reasonable with these things. Mm-hmm. If you come to them and you say, here's what we suspect may be a problem or may not, and here's what we're going to do to investigate it, they let companies follow that path and are receptive to companies coming in to providing updates. But you've invested and you've opened that door. And once you do that, the company loses a little bit of control of what's going to happen from there and how the DOJ will react and what other regulators internationally it may tell about what you've reported to them. And so from the company's perspective, I think the key steps are get as informed as you can, as quickly as you can. And if it looks like you really may have a potential problem, the incentives are set up so that self-reporting often is the best choice, but it has to be done with a lot of care and a lot of consideration about what the consequences are going to be and what you're going to do from there. What you don't want to have happen is to have an issue come in, run to the DOJ without a plan internally or with respect to your regulators about what you plan to do to investigate, and then come back and say, okay, what do we do now? That's just not the way to do it.
So, Brendan, would you be able to summarize, what is the index of concern that a company should have before it goes to DOJ or SEC?
So, in terms of some of the factors that I think you see at play in a situation where self-reporting is the way to go, you want to know how senior those involved are, how big a part of your business it is, how much money we're talking about, both in terms of payments potentially and gain to the company, how widespread, how long-standing, to the extent that it was done in a way that evaded your controls. How did that happen? Is it because your controls are not at all well put together? Is it because your controls are easily evaded? Is there an argument your controls were designed that way to permit easy evasion? Those are the kinds of things I think one weighs. There's no de minimis FCPA violation.
Right.
So what it's hard to say is, all this is one of my sales guys was going to get a ticket and he bribed a cop to avoid it. That's never going to be a problem. Well, that may not be a problem. That may be right. Or it may, so that really, even though there is no de minimis aspect of the FCPA, of course there is. No one's going to go nuts over a single guy bribing a single parking cop. What if you're in the business of driving around cities and parking illegally, and you pay people all the time? And in fact, there's a whole cash kitty sitting there at the dispatcher's office, and everyone gets their cash to go out and pay their. That's a very serious problem. Mm-hmm. And I think, as Laura said, the most important thing is to know what you don't know, and know that you don't know a lot. And the fact that what you know is it's a small amount of money, it's this one guy. You may be right, that may be what it turns out to be, but until you've actually gone and taken a look, you don't know.
But it's even worse than that, because knowing what you don't know can wind up being a books and records violation in and of itself. Because the DOJ has brought cases where they can't demonstrate that there was actually any bribery. The only thing they can demonstrate is that when you look at your books and records, you can't tell me that there wasn't bribery.
You can't demonstrate it either.
Right, you can't demonstrate it. You see, so nobody knows whether there was a bribe or there wasn't a bribe. What we do know is that like $3 million went to this consultant, and we don't have any confidence about where it went then. Mm-hmm. And those very often are some of the most difficult cases that you actually wind up encountering, because then what you've got is the books and records violation. Mm-hmm. You don't necessarily have a bribery violation, and trying to figure out whether this is the kind of situation that makes sense to self-report or not early on in the process becomes a very subjective process, and people of good faith can wind up having very, very different views.
This is another thing, I think I mentioned this in passing, but another very critical aspect of these things involves third-party agents of any kind.
Absolutely.
Customs agents, sales agents, lobbyists, any kind of person outside of your organization that your sales organization has decided they need to hire to help them make sales, particularly to state-owned entities, is a very, very dangerous area.
It's a red flag.
Compliance policies have gotten really good at tightening up petty cash and travel and entertainment. Because it's easy. You make people give you receipts, and then they otherwise are on their own, and they give you receipts. It's very difficult if someone says, I need that sales agent. That's a customer that requires a sales agent, or this is a country where I'm supposed to have a domestic sales. I'm required by law to have a domestic sales agent, so I have no choice. It's very difficult in those situations for a compliance organization, particularly one that isn't empowered to really ask searching questions, isn't empowered to really force sales organizations to justify everything they do. to test those assertions. And that is how people get in very, very big trouble very quickly. The $3 million that goes to some guy who has some function in some sale that was made, no one's exactly sure what it is.
In many situations, at a minimum, you're buying a books and records violation, all right? And worst case, you're also buying a bribery violation, which can evolve later, depending upon facts that you don't even know about at the time that you in good faith enter into this relationship with the local.
Exactly right. And that's why kind of the financial piece of it can't be overlooked. Oftentimes, the first time you get wind of an issue, right, you start trying to do that financial tracing to figure out if you can figure out where that money came from, where it went to, if you understand the purpose, because you're right, the books and records aspect is the easiest. And oftentimes, it's there regardless of whether there was bribery or not.
Exactly. Any other observations before we wrap this up?
No, I guess the only other topic we said we'd cover was something about the CFTC, and maybe we'll just briefly talk about their recent entree into the world of FCPA. So as we started off with talking about all the different organizations around the world that may be looking at companies with potential FCPA problems, we have another one in the U.S. itself, with the CFTC announcing in the spring that they will now turn their attention to companies that have FCPA problems. And of course, the CFTC does not have jurisdiction over the FCPA itself, but what it has said is that it will work with the DOJ with companies that are under its purview for CFTC regulations and take part in those FCPA investigations. And while we don't expect that to turn the CFTC into an aggressive regulator or investigator, it does mean that for companies that are subject to CFTC oversight, if they announce an FCPA investigation, they can very much expect that the CFTC will want to talk to them about that. And I think it will lead to more coordination behind the scenes between the DOJ and the CFTC. So just another audience, another potential source of reporting for companies that are thinking about FCPA investigations.
Yeah. Brendan, any observations?
I think we've covered every observation I came armed with.
The only thing that I would share basically is over the years, I've evolved a little bit of a fatalistic attitude about the FCPA in the following sense. Even if you have the best organization, even if you have the best compliance program, even if everybody does everything right, sooner or later you're going to have a problem if you're doing business in certain geographies, all right, and in certain lines of business. Okay. So, you talk about, hardware engineers. When you build devices, there's something called mean time to failure, all right? It's like, on average, this device will fail once every 7 years or what have you, okay? And there's part of me that sort of looks at all of these FCPA programs and says, well, all right, as we improve the programs, what we're really doing is we're increasing mean time to failure, and we're not guaranteeing that there will never be a failure. So my approach to this is, okay, you build the most rational FCPA compliance program you can. You've got to make it appropriate for the kind of company, the nature of business that it's in, so you've got to right-size it. And then you have to tell people candidly, at some point, even with this program, it will fail. And when it fails, here's what we're going to do. Exactly. All right? Here's how we respond. So what you need really to have is a compliance program. It needs to be appropriately sized and enforced. And then you need to have the tabletop exercise. This is what we're going to do when this program fails, because if we run it for 20 years, it's going to fail at least once. So let's lengthen the time to failure, let's optimize that, and then let's know how we respond if and when it fails.
And if I could add one thing to that, I think one feature of the DOJ guidance focuses on lessons learned. So continually innovating your program, not putting the program in place and letting it sit. But every time you have one of these issues that comes to your attention, turns out to be nothing. There are things to be learned from that issue, either substantively or about the compliance program and how it operated. And I think the DOJ will look very favorably upon companies that continue to innovate over time.
Well, that's the key thing. And the key point for innovation is pay attention to the new settlements as they come out, because you'll find new patterns of bribery or new types of actions. And if you adjust and adapt your program in response to that, that's going to be a plus mark if you ever wind up having an investigation.
Absolutely. So learn from other people's mistakes and troubles as opposed to your own.
Exactly right. It's much cheaper to learn from other people's mistakes than your own. There's no doubt.
Absolutely.
Yep.
So the only other thought which that reminds me of is one of the things that I find funny about the way the DOJ worded its new guidance on compliance.
Are you sure you want to use the word
The
funny?
second question, it is funny. I think you'll agree with me. The second question is the program applied earnestly and in good faith? Are they really trying to do the right thing? In other words, DOJ goes on to say, is the program being implemented effectively? Those are totally different things.
Right.
Trying really hard and doing a good job are not the same thing at all. But I think what that actually does point out is the first part's very important. You have to mean it.
Right.
You have to actually want to be compliant. It's the same with when you self-report and you cooperate with the DOJ. And I've seen DOJ lawyers say this at conferences. They say, it's hard to say exactly what are the hallmarks of a really good job of cooperating, except you know it when you see it. Because they're trying, they're actually trying to give you, the company, are trying to give you, the prosecutor, the information that you need.
Right.
They're trying to give it to you in a way that you'll understand. They're trying to give it to you in a way that will make you confident that you know everything you need to know. And that's really, I think, one of the hallmarks of a working compliance program is you need to be trying. You need to actually be trying to avoid misbehavior, trying to catch misbehavior when it happens, trying to fix the problems when you find them. And I think if you're doing that, you can read the 17 single-space pages that DOJ put out for guidance, but you'll probably find yourself meeting almost all of those requirements if you really are trying to do the right thing.
Right. And on that note, I think we have a wrap. Thank you very much.
Thank you.
Thanks.
Thanks, guys.